Hello everyone, I am Anubhav Sharma. I am the faculty of Indian Polity and Governance and Public Administration at Rao's IAS. And in this video, we are going to understand about the question that was asked in this year's mains, that is 2023 mains GS2, that is Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for progressive society. Illustrate with special reference to the expanding horizons of right to life and personal liberty. Students, whenever we see a question that is being asked in mains, I always advise to my students that you need to first make it easy for yourself. Try to break it down into smaller parts to exactly understand the demand of the question. What exactly the question is saying here? Let's look at it. It says Constitution of India is a living instrument and it has capabilities of enormous dynamism. It is very dynamic in nature. What exactly this statement means? It means that Indian Constitution is not just a letter. It essentially is capturing certain values, and in order to manifest those values into reality, Indian Constitution behaves in a dynamic manner. In this respect, what else it says? It's a constitution made for progressive society. What is the idea? The idea is this constitution is not a static document. It's not a document which essentially is explaining about what exactly is the state of economy, state of society of India today. It is talking about what exactly are the goals that we have set for the future. It has talked about how exactly we essentially are going to bring about a social revolution. What else? The question demands that we need to illustrate. Illustrate would mean what? That we need to give examples with special reference to expanding horizons of right to life and personal liberty. With special reference to right to life and personal liberty, of course, you must be knowing it is Article 21. With context to Article 21, we need to explain this point, this question. We need to illustrate. That would mean we need to give examples as to how exactly we see that Indian Constitution has shown dynamism. Make sense? In this aspect, what exactly we see? We see for any question, we need to have three basic parts that we know. Introduction, then body, and then of course conclusion. Let's talk about introduction. What exactly can be a good introduction? Now students, here's something that you need to understand is there is no one good introduction. There can be different ways in which you can introduce your answer in an effective manner. In this aspect, what exactly must be kept in mind? What must be kept in mind is that because in UPSC you need to write so many points and the time and space that you have to articulate your points is very less. It is very necessary that you are using your introduction in a way in which you are able to give some information, give some value to your answer. It should not be a very dry introduction. For example, here one of the introductions can be a statement by Granville Austin. What exactly Granville Austin had said? That Indian Constitution is not just a static document, it is a document which wants to bring about a social revolution. It wants to bring about what? A way in which we essentially are able to change the lives of the people. Why exactly he had said it? For the very simple reason he believed that on one hand we are writing right to equality. On the other hand, we are also writing as a part of right to equality, abolishment of untouchability. We are talking about giving equal rights to women. We are talking about ending discrimination based on caste, race. That means somewhere our Constituent Assembly is acknowledging these are those challenges that we have that we need to counter, that we need to change. And that is why we want to change the way in which a society is living right now. We want to advance it to, progress it to a better society, and that is bringing about a social revolution. As such, one can argue such an introduction where you're talking about the statement of Granville Austin is an apt introduction for there. For the reason this introduction is about what? How exactly Indian Constitution is trying to bring about a social revolution, a setup for a progressive society. Make sense? What else can be a good introduction? You can introduce by writing something about preamble. Under preamble of Indian Constitution, we commit ourselves to certain values, then list down some of the values of the preamble. That again is a way in which we essentially are able to give an introduction which is applicable over there, because the whole idea of preamble is what? To bring about certain values in the way in which our society is going to live: justice, republic, equality, democracy. From there, you can bring about and directly go into the demand of the question. Now, let's get into the demand of the question. What exactly it says? The first part says that, well, Indian constitution is a living instrument and it has shown capabilities with which it has shown a lot of dynamism. What exactly should you be writing? You should start your answer by giving example, giving ways in which Indian constitution has shown dynamism. You can give the example of doctrine of harmonious construction. Why doctrine of harmonious construction? For the very simple reason, what exactly was doctrine of harmonious construction? It said that Supreme Court will essentially read part 3 and part 4 of Indian Constitution, fundamental rights and DPSP of Indian Constitution together. Supreme Court is not going to look at only one part. It is going to look at both parts in order to harmonize individual rights with collective good of the people. In this respect, what exactly Supreme Court did? Supreme Court essentially undertook the idea of interpretation of Constitution in a way in which it is allowing itself to have a progressive interpretation. You can use the example of Sarla Mudgal case. What exactly had happened? Supreme Court, who essentially has been made the protector, vanguard, guarantor of Indian, that is fundamental rights of the student, of the fundamental rights of the people, of the citizens of India under Article 32. What exactly Supreme Court did? Supreme Court in Sarla Mudgal case said that when we look at Indian Constitution, what do we see? We see there is something called as a directive principle under Article 44, that is Uniform Civil Code. State should try to create a uniform civil code. In this respect, what exactly are we saying? If a Muslim man, if a Hindu man is converting into a Muslim and then he essentially is practicing polygamy, while he might be doing it under this Article 25, that is right to religion, it certainly is not right. It is not a progressive interpretation, because you also have something called as Article 44, that is Uniform Civil Code. That means what? That means the fact that for Uniform Civil Code, which is a DPSP, Supreme Court gave an interpretation where Article 44 was given primacy over Article 25. Just because you're changing your religion into Islam does not mean you will get polygamous right of a Muslim man. What exactly it means? It means that we get a progressive interpretation where we are not letting fundamental rights to come in the way of what exactly is required to create a progressive society. That means one can argue that harmonious construction can be looked upon as a way in which Indian Constitution is showing dynamism. What else can be written over there? You can also mention about doctrine of essential practices. What exactly is doctrine of essential practices? Doctrine of essential practices says that whenever Supreme Court will need to look into protection of religious rights of religious community and it is against individual rights of people, Article 14, 15, 16, Supreme Court will always try to protect only the essential part of practicing your religion, and if at all the practice is something which is not essential, Supreme Court will give primacy to individual rights of the people. What does it mean? Think about it. In Sabrimala, what exactly had happened? There was a group of women aged between 10 to 50 years. They wanted to go and pray to Lord Ayyappa. They were being denied entry into it. Why? For biological reasons. What exactly Supreme Court said? On one hand, we have Article 25, 26 of the devotees of Lord Ayyappa, who believe this is a ritual they need to practice. On the other hand, we have individual rights of women who wants to go and pray to Lord Ayyappa by entering into the temple. In this respect, when we look at this issue, we see not allowing women into temple, entry into temple getting banned to women based on biological factor, that is they might be menstruating, is something which is not an essential practice in practicing Hinduism. As such, Supreme Court did what? Supreme Court protected individual rights over religious rights. Something similar Supreme Court did with respect to banning of talaq-e-biddat. What exactly is talaq-e-biddat? That is instant triple talaq. What exactly Supreme Court did? Supreme Court said that instant triple talaq is not an essential practice under the practice of Islam. So this is something which will not be protected in the fundamental rights of Article 25 and 26, and that is why we are protecting Article 14, 15, right of equality, right against discrimination of women on such matters. As such, talaq-e-biddat was discontinued. Even with respect to Haji Ali Dargah, entry of Muslim women into the Dargah was allowed because of this doctrine. As such, again, what exactly do we see? Indian Constitution essentially made space within provisions of the Constitution in a way in which it led to a more progressive interpretation, an interpretation where we essentially are able to balance religious rights with individual rights in a proper manner, in a progressive manner. What else you can write? Another point that you can write over here is with respect to creation of GST regime, bringing of GST regime. Now you may ask that sir, GST regime does not seem to be an apt point over there. How exactly GST regime can also be looked upon as a way in which Indian Constitution has shown dynamism? Think about it. Indian Constitution provides for a quasi-federal state, that is, in Indian form of federalism, union is more powerful than the states. In this respect, what is the idea? The idea is that one of the ways in which we want union to be superior to state is by state being dependent on union on all matters of finances. That is one of the reasons why we had to create Finance Commission, which can give recommendations to union on matter of distribution of financial resources, that is distribution of tax collected. In this regard, what exactly are we saying? What we are saying is that when Indian Constitution was created, we essentially wanted supremacy of union on financial administration over states. With creation of GST regime, what we have done, we have shown dynamism. Dynamism in a way in which we essentially are moving away from union dominating states to a cooperative federalism where we would want, with creation of GST Council, even states to participate in matters of financial administration. That again can be taken as one of the examples in order to make your point. I hope you're able to understand how exactly these provisions that I have mentioned depicts the fact that Indian Constitution has shown dynamism in a way in which it essentially is leading to progressive ends. Make sense? But then the second part of the question is also talking about that we need to talk about, give examples with respect to right to life and personal liberty. What exactly should be the second part of our answer? We need to talk about right to life and personal liberty, which we know is an article under Article 21. What do we know about Article 21? We know this is a fundamental right which says that right to life and personal liberty of a citizen cannot be taken away, of an individual cannot be taken away, except for a procedure established by law. In this respect, we know the fact that this procedure established by law as a judicial review doctrine has underwent an evolution. Evolution with respect to what exactly it means. In this regard, what you can do is to mention about Menka Gandhi case. (1978). You can mention about how exactly in Menka Gandhi case, Supreme Court interpreted procedure established by law to be procedural due process. It essentially gave power to Supreme Court to look into cases where what is happening, where the procedure made by the state is not good. In this respect, what exactly Supreme Court had said in Menka Gandhi case? Supreme Court had said the fact that whenever a law is created, Supreme Court has the power to look into procedural correctness. That is, procedure for any law will need to be just, fair, and reasonable. In this respect, what exactly has happened? What has happened is that Supreme Court has expanded the scope of Article 21, and within interpretation of procedure established by law, Supreme Court has interpreted it includes procedural due process. Not just this, what exactly Supreme Court had done in Menka Gandhi case, Supreme Court had held Right to life and personal liberty is not in a narrow sense, cannot be interpreted in a narrow sense, cannot be subjected to mere animal existence. What does Article 21 means? What does right to life and personal liberty means? Right to live with dignity. Right to live with all aspects of life which makes your life to be meaningful. In other words, Supreme Court held right to life, Article 21, includes penumbra of other rights within its ambit. And that is the way in which what exactly is happening. Article 21 can be expanded to include a number of rights. In this regard, the question says that we need to illustrate it. We need to give examples with respect to right to life. What exactly can be the examples that you can give? One is, of course, Menaka Gandhi case. But then you can also talk about Putta Swami judgment, that is right to privacy. You can talk about the fact that in Putta Swami judgment, what exactly Supreme Court had done? Supreme Court essentially had identified right to privacy to be a part of right to life. What exactly Supreme Court did? Supreme Court was able to recognize that privacy is an important component that a person should have in order to enjoy his right to privacy, his right to life. Without privacy, right to life with dignity is getting compromised. What else is the example that you can use? You essentially can talk about Navteet Singh Johar judgment, where Supreme Court essentially had recognized LGBTQ rights. Supreme Court had recognized the rights of transgenders. Supreme Court had recognized the rights of the people who essentially are not from male or female. In this respect, what is the idea? The idea is, again, Article 21 essentially became that fundamental right where we essentially were able to expand it to include other rights which were not part of it originally. What else do we see? Even right to education, RTE, right to education, was identified by Supreme Court in 1993 to be a part of Article 21. Supreme Court said that right to get education, right to literacy, right to read and write is a way in which a person is able to bring dignity to his life. Without it, the dignity, personal liberty of an individual is getting compromised. As such, again, what exactly happened? Subsequently, right to education was added in Article 21. We all know it is Article 21A. As such, we were able to get what? We were able to get another fundamental right. If we are able to mention these points, what will we have? We essentially have done justice to the question. The question required us on one part to explain about how exactly Indian constitution has shown dynamism that we have. On the other part, the question wanted us to give examples how exactly Article 21 has been interpreted in a way in which it has led to expansion of Article 21 to include more rights. If we are able to do justice to these two parts, the body is fine. So now we have the intro, we have the body. The last part is conclusion. Again, in conclusion, I always recommend it's an opportunity for students to be able to stand out by giving something which adds value to your answer. You should be writing something by which you essentially are able to do what? You are able to give one more reason to the examiner to give you more marks. In this respect, what can be a conclusion? The conclusion can be an observation made by Supreme Court in Menaka Gandhi judgment, where P.N. Bhagwati had said that right to life is not about mere animal existence. Right to life includes all those aspects which makes a person's life meaningful. What else can be a good introduction? What else can be a good conclusion? Another good conclusion can be, we essentially write that in recent times, questions with respect to homosexual getting married, marital rights of homosexual, issues regarding to marital rights, that is marital rape, are under the ambit of discussion of is it included under Article 21 or not. I hope you're able to understand what we have done in this kind of conclusion. We have given some more examples with respect to recent things which essentially are being discussed. Should it be included under Article 21 or not? And that is how we are able to provide a good conclusion. I hope this video was helpful to you. Thank you.